Welcome today to this conference. I will just have a brief word to say, and then I will hand the podium over to Professor Wong. We'd begin this morning, as we began yesterday, by acknowledging the people of the Kulin Nations. They are the traditional owners of the unceded land where we are gathered. And I'd like to pay my respects to their elders, past, present, and emerging. And we'd like to express appreciation for the important cultural heritage work that they do in the Melbourne area. I'd like to call now Professor Wong to the stage, and he will introduce Professor Martin Pittard.
All right, good morning, everyone. So welcome to the day 2 session. So the first activity today is a keynote by Professor Martin Pittard. It's my great pleasure to introduce Professor Pittard. He's currently a professor of economics at the University of Mannheim in Germany. He's a leading figure in the research areas of industrial organization, competition economics, and the digital markets. He is currently a member of the Competition Economics Working Group at the Bundeskartellamt and was a member of the Economic Advisory Group on Competition Policy at the European Commission DG Comp. Martin currently serves as an associate editor for both the Journal of Competition Law and Economics and the Information Economics and Policy, which I understand are very reputable journals in the policy circle. Notably, his textbook on industrial organization and the economics of platform have become the essential reference for people who want to explore those areas. So today, Martin will discuss with us the whack-a-mole challenge for tech regulator. I will leave 5 minutes at the end for Q&A, and then we'll follow by a panel on similar topics, so we'll have more time for Q&A at the end. Martin, the floor is yours.
Thank you very much for the kind invitation, and I'm very happy to be here. I understand it's 50 years of competition law in Australia, and I'm not going to tell you anything about Australia since you're better placed than me. I will tell you a few things about what I see as important areas of development in Europe with a lot of question marks. So we will see how things will be going. So I will talk about what I call the whack-a-mole challenge for tech regulators, where tech regulators can be understood broadly. So to a certain extent, also a competition authority can be, or even has to be, depending on the law, a tech regulator. I will provide, for those of you who are not very much in the topic, some introduction, hopefully some facts, but I always add some opinion. Then I will tell you a little bit about the Digital Markets Act, its scope, and what I think how a proper enforcement under the DMA should look like, and we still don't know how it will be done. There were some people celebrating when the DMA was passed that finally economists are out of the room, that they are no longer needed. And of course, being an economist, I think this would be very bad. And I think there is scope and there is room for economists to play a meaningful and useful role in the enforcement of the Digital Markets Act. And I will explain that in general terms and use one particular prohibition from the Digital Markets Act, which is the prohibition of price parity clauses, as an illustration and to tell you where I think the role of economics at least is. Of course, I understand that many lawyers also think that they're good economists. So then, of course, also the lawyers can do it, but from an economics perspective. Okay, So my introduction draws on many things, and since we don't have that many ideas, but many papers and pieces. So yeah, that's one of them, governance and regulation of platforms. Well, even for those who are not very much following what is happening in digital tech markets, standard newspapers report about it. So it's difficult to avoid at least the perception that there are competition challenges in tech markets, with several firms having become mighty players, and well, might also depends, of course, on the kind of markets they're operating. So it's not necessarily only the big tech players, but also some companies which if we're not operating or don't have any particular interest in such a market, may overlook. But if you look, say, at gaming, streaming, music streaming, and others, I mean, we do have relatively big players. They, of course, tend to complain about the big tech players, but in their own markets, they may act in a similar way, making life hard for some participants. And I think the important aspect, and I think that one of the question always is, I'm asked, I mean, digital, what is really different? I mean, is it just a label? Of course, partly it is a label. But what are perhaps the two key distinguishing features, and possibly and also some of the competition problems arising from those, compared to other big players, which in a way also served as platforms? If you think big US shopping malls, that was conceived to be a big problem at some point, I mean, they are, of course, also platforms. What makes it some different? And I think there are two issues. One is, and that one I won't address today much, well, I think I mention it now, is scalability. Of course, you could also scale physical businesses. That was done, but not with the same ease as it is done in digital. And scalability means scalability in space, if you want, or user segments, but also in terms of activities, incorporating vertically related, horizontally related activities. And some of these relations may actually then stem from not the particular technology which is used, but possibly just some information which is gathered through data. And I think the second aspect, and I think that's much more relevant for what I'm going to talk today, is that we can view many of the platforms in a way as private regulators or rule makers. They do many more things of what other platforms in the non-digital world had been doing. Of course, it's always it's not black and white. Clearly, shopping malls, for example, also have very clearly established rules on what shops can do, what they cannot do. They also have integrated quite a number of services. So I'm not saying it's 1-0, but what we have been observing, also many of the complaints, is about things not just about that it's too expensive to be there, but also all the other things a participant, a user, is supposed to do. And I think the general part of the general discussion is what are the kind of rules which a private regulator, such as a platform, can make, and where does the government, where does the authority have to step in and impose certain rules or remove certain rules. And all this in a dynamically evolving environment, which makes it very hard, and which I think is one of the big challenges of the Digital Markets Act, where technology is changing. In response, business models are changing, but of course, I'm not saying the causality just goes in this way. Also, sometimes just business models change, and as a result, technologies change. Okay, so this business model change, technology change, those two are connected, and then we are supposed to have a stable regulatory framework which is forward-looking. So that's pretty hard, and of course the legislator which introduced the Digital Markets Act saw this challenge. I'm not sure whether they did it well, but at least that's what we're going to talk about. The Digital Markets Act comes together with the Digital Services Act in the EU, both approved and put, we start with the enforcement this year, but they were approved in 2023. Now, the Digital Markets Act it's an asymmetric regulation, meaning it applies to a certain set of firms, which will be, as part of the how the digital markets work, will be identified. So they will be designated as a designation process. It's an ongoing process, but that step has been done in a way most people were expecting it. So it's the big US, the 5 big US firms where the whole thing was started, and then there is ByteDance and now also Booking. It has been done in a very mechanical way, namely there are some quantitative criteria which create a presumption, but that doesn't mean it has to be in. Also, if you're below, you could be in, but so far it was just based on those numbers, which in a way also then shows that the lobbying money spent by some of the European players was well spent money, because they argued on how to move up a bit those thresholds so that the presumption doesn't work. Okay, and but that's not all. So it's not just about identifying firms, which is different, for example, from the designation according to the German competition law, which has this element of tech regulation or crazy regulation in there. It's also about which services enter in a so-called core platform services, because the regulation doesn't apply to the company as such. It applies to activities which are related to those core platform services. And there has been more discussion, and also there has been some initial steps by the Commission, then the Commission retracted. So I think that's a more dynamic element to talk about which core platform services enter and which services are not called core platform services. And then this is supposed to be complemented by the Digital Services Act, which is, on the one hand, it's a horizontal regulation, so it's something which applies to all. But then also it has elements of asymmetric regulation, because it also contains particular obligations to what is there called a very large online platform, and you can be designated under the Digital Services Act without being designated under the DMA, and vice versa. Okay, so these are two, in this sense, there are two different sets, and the goals on of the Digital Services Act are somewhat different. I'm not going to talk about this. What we now have in the UK, the Digital Markets Competition Consumers Act, which that's a different label. It's called the Strategic Market Status. So if you receive an SMS, that's something different for a large firm than if you're using your smartphone. And what this act contains is it's a mandatory merger reporting requirement, and their conduct requirements, which is about the rules a firm imposes and the way it interacts with consumers and businesses. And under this act, the Digital Markets Unit, as part of the CMA, can impose behavioral and structural interventions. And that, so at this high level, it's very similar to what is the Section 19A in the German Competition Act, which has been passed before so it was the front runner for all that. And so in that sense, the UK regime is much closer to competition law, and it's the Digital Markets Act which has moved much more towards a kind of sector regulation. And I think that makes the DMA much more challenging than, say, the UK regime. In the UK, the question is about effectiveness. And in I think at the EU level, the question is about, well, what does this DMA do? Is there still scope for actually looking at reaching the goals, or does it just become a very mechanical exercise of imposing certain restrictions which are not really based on whether there are any market power issues, abuse issues? It may become just a very bureaucratic exercise. Now, it's important, I think, to see that the DMA in the EU is part of a much broader set of ways to address competition problems. So, of course, we do have competition law provisions which are still used. Yeah, so it's based on 101, 102 in the EU, and we do have the merger regulation. There are, in some member states, additional competition law provisions which can be very powerful in the context of digital markets and digital platforms. One of them is Article 20 in the German competition law about relative market power. So that's in a bilateral relationship. We do have the market investigation tool. At the EU level, we don't have any remedial actions, but in more and more EU member states, we do have now market investigation with remedies built on the UK experience with that tool. And there are new calls in the EU to also introduce such a market investigation tool at the EU level at some point. So I should, as a disclosure, I wrote the economic expert report together with Massimo Motta for the EU. Then it was shelved for political reasons, but now there's a revival of the discussion. We have quasi-regulatory provisions in some of the national competition laws. I already mentioned Section 19A of the German competition law, which is, as I said, very close to what we have in the UK Act. And it means, and it hasn't become superfluous, because since the DMA is a regulatory tool, while it can be, may have sharp teeth, we will see, but it can there's only particular prey out there, and there's others which will escape this regulatory tool, whereas 19A is much more flexible, as is the UK competition provision, which of course now is outside the EU. And what we also have seen, and and I think, I mean, if I'm critical about the DMA, I should be even more critical about some of those legislative actions, is that some parliaments can be very active and very quick in discovering a problem and avoiding it by prohibiting certain things without analyzing them. And well, I wouldn't say that this necessarily happened, but okay, so my example about legislative action is the French law to prohibit any price parity clause in the hotel booking sector. I mean, there were big complaints in the tourism sector in France. And so we do have that as an option. And for those who are working in private company and always lobby against regulation and against new rules, competition law-based rules or quasi-regulatory provisions, or also a strengthening of the market investigation tool, I would like to remind those people that there's always the possibility that Parliament is becoming active, and sometimes actually good to have regulatory rules because it tames the appetite for opportunistic and short-term interventions by parliaments. Okay. Oops, this was not intended. Okay. Now, getting back to the regulation part, I think it's all EU regulation is supposed to be future-proof. And I think future-proofness, that's a big challenge, in particular in tech. And so there is always a concern about legal certainty. There is a concern about possible overreach, but of course there's also a concern about the tools not being able to address the real problems and just bite at the smaller pieces without looking at the big, being able to really deal with the big problems. And the approach taken in the EU is really to identify specific practices which are problematic and to regulate them, meaning that certain things are prohibited and others are mandated. And so in that sense, it's really a regulatory approach, very different from UK or the Section 19A in Germany. But then new market developments, plus their strategic responses by players. And so I think that's the big challenge. Even if, suppose that as of today, we are able to identify the problematic practices and can then have a regulation dealing with those, these practices may change. And the other problem is, and I think that's even the short-term problem, that certain practices may only be problematic in particular environments with a DMA that's not dealt with, to the extent that just the designation isn't enough to identify the environments which are problematical. Okay, so I'm not a friend of the DMA, but the DMA is there, and I think it's also not it's very futile just to always just go against it, but we have it, and I think the question is how best make use of it. So that's then not a lesson necessarily for Australia, but at least it's how we should deal with it in the EU, and at some point then it affects the trade-off between having a flexible instrument with a risk of both overreach and under enforcement, or a more stringent regime such as the European one, where of course you also make those kind of possibly make those errors. I think the big challenge then in the EU in particular is how to update regulatory practice. And that's where we need economics, of course. If you don't do economics, then you will have a big problem having a future-proof DMA, which works well, reasonably well. And what I will present from now on is based on a recent article in the Common Market Law Review, together with my colleague in Mannheim, Jens-Uwe Frank, who's a great lawyer. Okay. So what's the DMA? The DMA contains prohibitions and obligations specified in Articles 5, 6, and 7. So 5 and 6 had been around in a long time discussion, and Article 7 was kind of moved there, they slipped it in at the request of telecom players and rather last moment. That contains obligations and prohibitions, and possibly they can be specified, made more concrete through so-called implementing acts. And then there are other practices, and there we don't know what happens to those practices. And dynamically, there is a whack-a-mole challenge that certain practice is prohibited, and then you use a different practice, which works in a rather similar way, but at least from a legal definition, these practices are different. And I think what to do with them. So the DMA does foresee that this can happen. Fortunately, the discussion there was a long discussion of the DMA, and many people said, look, I mean, this is the wrong approach just to label certain practices and say they are prohibited or you have to do certain things. And therefore, we do have the anti-circumvention provision, and there can be additional implementing acts which specify then what was originally prohibited, what can also on top of that be prohibited, and also in terms of mandation, which other practice can be mandated. So that then defines the scope of illegal practices under the DMA, and what is left is the legal practices. However, there's one other thing, so that's not necessarily just anti-circumvention. There can also be delegated acts which extend certain types of obligations with the overall spirit of the DMA. So you can't put in different general objectives, but based on the existing objectives, this can also be done, and there can be amendments to the DMA, and that's another way of future-proofing, if you want, the DMA, and that takes more effort and more time. So therefore, the natural one to first deal with circumvention practices is to apply the anti-circumvention article. What does this article say? The gatekeeper shall not engage in any behavior that undermines effective compliance with the obligations, which are spelled out in those articles 5, 6, and 7. And regardless of whether that behavior is of a contractual, commercial, or technical nature, or of any other nature, or consists in the use of behavioral techniques or interface design. Okay. So rather broad. And in recital 70, it's phrased different. So similarly, it is important that the obligations are not circumvented. To that end, the rules in question should apply to any practice by a gatekeeper insofar, and I think that's key, as the practice corresponds to the type of practice that is the subject of one of the obligations. So what does it mean that the practice corresponds to the type as set out in Articles 5, 6, and 7? Well, I think the only reasonable way, or I haven't seen any other reasonable proposal to deal with that, is to have a market effects-based approach to decide on what really corresponds. So our proposal is that a business practice should be considered a strategy to circumvent an obligation if it can lead to a market outcome and economic effects equivalent to the one that the obligation question seeks to avoid or achieve. So that's our proposal. It's not in the DMA. The DMA doesn't say anything on how anti-circumvention is supposed to be interpreted. It's left open. In the end, the courts will decide. Of course, the Commission could provide some guidance as to how it intends to interpret anti-circumvention consistently. It hasn't provided this guidance yet. I think the Commission should really spend resources on that and clarify what anti-circumvention is supposed to mean. And we propose a 3-step procedure. Well, first, that's for a particular obligation in a particular context, so for a particular gatekeeper platform and associated core platform service. Which market effects does the DMA obligation actually seek to achieve or avoid? Because if we want to establish equivalence, what in the wording of the DMA is a correspondence, well, we have to first say, well, what is actually intended to be done, right? And then we have to look at the other practice where we think that's possible a circumvention strategy. What are the market effects of this business practice that is suspected to be a circumvention strategy? And then we have to look at equivalence. So what is the obligation intended impact on the market? And what are the market effects of the suspicious business practice? They have to be compared, and equivalence has to be established, where equivalence is also, of course, not a 1-0. It's not that exactly identical, but it should be close to what the original obligation did, going in the same direction and being, in a way, economically significant. Now, the DMA sets out two overarching goals, contestability and fairness, where contestability is somewhat better understood than fairness. And I think when we want to evaluate what are the effects, we should have these two overarching goals in mind, because if we don't, we cannot invent other goals. So we should look at what are the intended effects related to contestability, say how easy is market entry, and fairness, which is how are rents distributed within this digital ecosystem between the different types of users and the platform. Now, we are not reintroducing an efficiency defense, and that's very important. I mean, that's always a critique which comes from the lawyer's side. You economists, you always want to have an efficiency defense. So this is not, and it can't be, because this is would be against the spirit of the DMA. So we may like it, but that's not how it would be done. It's really based on those two goals, contestability and fairness. With respect to those objectives, the practice is both the one which is already in the DMA and the ones which are suspected to be circumvention strategies. So I think that's the overall take we have on the anti-circumvention rule, how the Commission should use the anti-circumvention prohibition in the DMA. It's not clear how it will use them. It's early days. We know quite a bit on designation. Now it's about enforcement. And I think in the next 2 years, probably we will know more of how the Commission will interpret the anti-circumvention prohibition. And then at some point, we also will hear how the courts will interpret that. For those of you who find that a bit too abstract, I would like to provide you an illustration to see what are possible anti-circumvention strategies and on what basis they can be possibly evaluated. And for that, I use price parity clauses. And I think that's nice, because at least we know, we understand well what that prohibition really means. With some of the other prohibitions, there may be already a discussion of what that the prohibition which is written down in the DMA explicitly, what that is exactly supposed to mean. One example there is the self-preferencing prohibition, where it's not always clear of what is actually a violation of self-preferencing. I think with price parity clauses, at least that part is clear, and therefore it's works well for illustrative purposes. So there can be narrow price parity clause. So there's so there are different sales channels, and the question is, can I offer lower prices as a seller or as a say app provider on alternative sales channels? Can I use my own sales channel and provide better terms and conditions? Can I use competing platforms with their sales channels and offer better terms and conditions. Competition law has been used so that the imposition of price parity clauses can be dealt with as abuse cases, and it has been done. It has been widely done in the EU in many member states. Hotel booking is one example of that. We have many cases, the reason being that the European Commission decided not to make it a European case, but rather cases in the individual member states. And therefore, we have quite some experiences on how different national competition authorities within the EU view those contractual provisions, and they reached different conclusions. Okay, now for those platforms which have become designated and whose core platform services are included there, now the DMA is clear. The gatekeeper shall not prevent business users from offering the same products or services to end users through third-party online intermediation services or through their own direct online sales channel at prices or conditions that are different from those offered through the online intermediation services of the gatekeeper. Okay. What's the motivation behind 5.3? Well, the abuse cases in the EU and outside the EU. They are well-developed theories and empirical analyses of the economic effects. And they show that there is concern, not as much as in 5.3, but there is at least some concern. So we had in the member states competition practice going against price parity clauses in this overarching or in a much narrower sense. We did have the interventions by legislators. The regulatory objective is well understood, and it's also practical significance. In the DMA, Amazon, Apple, and Booking all had cases of price parity clauses in the past. It's also something which seems relatively easy to enforce, at least in its direct and its immediately observable form, when a platform explicitly makes those contractual obligations and takes strong actions against anybody violating those clauses. Okay, so it's perhaps useful to look at how 5.3 is what is the argument behind 5.3 within the DMA. So there are two places looking at recital 39 to ensure, so the purpose is to ensure that business users of online intermediation service of gatekeepers can freely choose alternative online intermediation service or direct online sales channels and differentiate the conditions under which they offer their products or services to end users. Should not be accepted that gatekeepers limit business users from choosing to differentiate commercial conditions, including price. Okay. So in case you thought the legislators are concerned about price discrimination, apparently here not. It wants to make sure that at least sales channel specific price discrimination is feasible. And there's another point in recital 39. So that's the first sentence. In certain cases, for instance, through the imposition of contractual terms and conditions, gatekeepers can restrict the ability of business users of their online intermediation services to offer products or services to end users under more favorable conditions, which includes price. So it's similar, but it's not identical, and it will be difficult at some point, possibly in some cases then, and the court may have to decide on which part of the recital it will really use. Now, if we think about what are the kind of things covered under 5.3 initially, so there are these 3 lines. So first, it could be just price parity, but it makes clear it's not just about price, it's also about non-price elements. So that's larger, and its practice is preventing from offering products at different price or conditions. So it's not necessarily just this contractual clause. It could be other things the platform does, perhaps not even as a contractual clause, just as a expected behavior by the business users. So business users fear what will happen. And for that reason, this practice may already be covered under 5.3. But, and that's at least I see the advantage of the anti-circumvention rule, is that at some point you don't really have to finally say if this practice is really directly covered under 5.3, or is it just very close, but then covered under the anti-circumvention. Okay, so I think in order to apply anti-circumvention, we have to think about the intended market effects. And there we should distinguish between the 2 different types of price parity. There's this across platform parity, which is in general seen as welfare reducing. There's a contestability problem because sellers then cannot pass lower commissions fee on to consumers through lower retail prices. So here, so cross-platform parity can be seen as violating fairness considerations as well. And then parity with respect to the direct sales channel, narrow price parity clauses. They are not welfare reducing if they're really necessary to avoid a free rider problem, and there is on top sufficiently intense platform competition. And actually here we are also benefiting a lot from research done by Chengxi for these economic mechanisms to understand them better. Now, the prohibition in that sense answers both to the contestability and the fairness objective. So it's about lowering entry barriers for competing platforms and providing competitive pressure on commission fees, which, if there is some pass-through, lower commission fees then are better for business users and end users. We don't have to discuss, well, if there's a conflict between the two, what is then the stance actually of the DMA? Now we can look at different practices and claim, well, they could be suspected of being circumvention. And at some point, the commission will have to say yes or no. And what some people thought is, oh, we just look, if we prohibit it, and now suddenly we see another practice, well, that must be a circumvention strategy. I mean, this is, of course, nonsense. It's nonsense for many reasons. The first nonsense is there are permanently changes in business practices, so it may be just coincidental. Secondly, the DMA intends to change the behavior of the platforms, and of course, they will have to do something. So in that sense, if they do something, not anything they do can be automatically be called now a circumvention. And the third aspect is, that's I think more important and even less on the mind of some of the policymakers, is that while they sometimes understand that platforms, those who are running those big platforms are not stupid, they also, it seems it hasn't occurred to them that when a prohibition is in place and things are changing, it's not that suddenly we will see now a response with a new business practice. No, everything will be done knowing that the DMA is in place, and therefore it will be just very hard, but by any means, just based on timing to identify whether something is circumvention any sort. So I think even if you hate economics, you have to think about effects. Otherwise, you're lost. I mean, then it's becomes a guessing exercise of what rule is a circumvention rule, what kind of behavior is circumvention, which one is not. Okay, so first, as a test, exclusivity. So that means a product can only be offered via the platform if exclusivity is accepted. Alternative, which may already be covered, but here we look at it as a circumvention strategy to the prohibition of price parity. And that means, by definition, if it is enforced, there will be no off-platform transactions. And we would argue very much in favor of equivalence here. And in a way, the recital in the DMA, one of the sentences speaks to that, because it mentions delisting of the offers of business users as an example of measures that intolerably restrict business users' freedom to use alternative online distribution channels. Okay? And therefore, we would say, well, it's either directly prohibited already under this interpretation of 5.3, or at least covered by the anti-circumvention prohibition. Second, deranking. So that means, as a response to lower product prices somewhere else, the platform puts this offer in a worse ranking position, reduces the visibility on the platform. And that's less drastic than the complete removal. But the intention is very similar, and the effects are very similar. And also here, we would argue that a substantial deranking, in effect, comes close to a policy of delisting, and therefore, this should count as a circumvention strategy. And therefore, deranking should be considered illegal under the anti-circumvention prohibition. Third interesting practice is what you can call undercutting, namely that the platform reduces the price on the platform at its own expense. So it accepts a lower commission fee to match lower prices elsewhere. Yeah, that's what, for example, Booking announces. Booking may give an incentive with respect to the room price at its own cost. In such case, Booking.com shall pay part of the room price on behalf of the guest. Great, yeah. Booking is working for us as end users. What are the market effects? Well, it can possibly dampen the effect on competition, in particular in combination with narrow price parity. It has the same effect than the wide price parity clauses. Now, absent narrow price parity, and remember, they are also prohibited under DMA, so we cannot use that argument. It's really unclear. And therefore, I think the equivalence here really depends on the circumstance. We cannot say in general, this is an illegal anti-circumvention strategy. It depends on the particular situation. Therefore, it may be different depending on the particular core platform service and the particular platform we're looking at. And it depends a bit on the focus. So in particular, if the competitive pressure by the direct channel is weak or non-existent, then of course that part of the argument breaks down, and that speaks in favor of equivalent. And also it's a bit of thinking about the rationale. Are we really, what is our interpretation of, say, fairness? And that also may be decisive about whether we call something equivalent or not. And interestingly, in one of the member states in Portugal, there's a legislative intervention banning this selling at a loss. And in Europe, we are very much concerned about fragmentation within the market. I mean, it's very fragmented in many ways in any case. But so at least the DMA, the hope is that it will reduce this this fragmentation, because once there's some some decision under DMA, it will also affect decision making under traditional competition, or it will affect the legislators in the member states, more important. Now, a fourth possible strategy, which may be considered to be anti-circumvention, is moving to an advertising finance business model. What is the problem? Why price parity? Well, I mean, because some transactions are carried out outside the platform, even though the platform may have played a relevant role for information gathering of the users. Yeah. And one response then is, of course, to say, well, if that's the problem, then we make money somewhere else, namely to create that visibility, which would be more of an advertising finance business model. So it can be clearly a response to such a prohibition. So here the platform directly monetizes its gatekeeper role. We would argue against equivalence. Even though this is a clear response to the prohibition, it's not equivalent, because sellers can independently determine conditions for each transactions, and there's no reduction of platform transactions. So therefore, we would argue that there are limits. And there have been always a question, what are the limiting principles when we apply the anti-circumvention prohibitions? And I think you can only work with an effects-based approach. Otherwise, it's pretty much random. Okay. So let me conclude. If you go for sector regulation, you should think about in dynamically moving industries in industries which are very heterogeneous, how well that can work, how well that can ever work, and how well that can work in the future. The DMA tries to be future-proof, in particular with the anti-circumvention prohibition. And I think it will depend very much on how this anti-circumvention prohibition will play out in the real world, of whether that goal is achieved in a good way, or whether the DMA fails. So I think anti-circumvention is at the core of the success or failure of the DMA, and I provided some views on how it should be done. Thank you very much.
Okay, thanks, Martin. That was excellent. And I completely agree with your bottom line that the effectiveness of the DMA will depend on the ability to enforce anti-circumvention. I'm more pessimistic than you about whether the equivalence approach, which I agree is what we'd like, whether it will actually work. So you presented, I think, 4 different cases, and you said, well, let's start off with one that's pretty clear, and let's go through to, I think it was the price undercutting, which was the most...
The last one which made it.
Yeah, well, which sort of, this one's, yeah. I think all of them are ambiguous. And let me go back to exclusivity, which sort of seems, yeah, this is just price parity clauses, but, you know, it's sort of harsher than a price parity clause. But if you're a firm, you can't do price parity clauses anymore. Maybe you're going to offer different packages to customers that want to advertise, say, their hotels on your platform or put their prices up there. And one package will be, hey, guess what? If you only advertise on my platform, you get the lowest percentage take, so the lowest fee. By the way, you'll get the highest rankings on my platform. You'll get bigger pictures. It'll be easier for the customers to click through. If they click on something that's not an exclusive hotel, maybe before they get to the hotel that they've clicked on, they'll get, did you realize that this hotel is available in the same location and it offers a better price? So I can imagine you can come up with exclusivity things that start to do as much, if not more damage than price parity. But hey, it's just a package open to the sellers. I mean, do you rule that out? And if you rule that out, I mean, to what degree does it mean that the regulator is sitting there essentially in the boardroom making the pricing decisions and the price package decisions for the business, for the platform?
Yes, so I think exclusivity at its simplest form, as I presented it, is easier to deal with, and we're kind of can move from full exclusivity. There's a continuum to no restriction whatsoever, and I don't know exactly where will be the line, but somewhere it will have to be drawn, and hopefully it will be based on thinking about what are the economic effects. Are they strong? Yeah, to what extent? It's so when you have these different packages, I mean, some maybe almost look like fake packages. So in a sense, they are offered, but they're not never really chosen. Then it's somewhat simpler. If it's less clear than that, you may have, and so the fear is that it will be whenever there is, it can be construed that there is some form of exclusivity, everything will be ruled out, and that would be extremely invasive. So, and I haven't been saying that I'm optimistic. I only say that I think that's the best we can aim for, and I hope we will be going, and I'm not even sure we will be going that way. So it could end up much worse. But even if we're going that way, of course, it's not clear. But I mean, the same happens when we run an abuse case. So we shouldn't kind of say that. We should never have the expectation that the DMA now solves all our problems, but also it's a bit unfair of say the DMA faces all these problems when we are facing these problems in any case.
Quick question, please. Thanks.
Just a question, the rationale for the DMA in the first place is partly that it should be quick and easy to apply. You have clear, bright line rules. And then the discussion here around anti-circumvention, getting into effects analysis, potentially that's going to be very difficult to apply, complicated to apply. So just curious what your view is then. Potentially, if something, an additional practice is found under the anti-circumvention rules to be equivalent, would it then be added to the list of prohibited conduct? And maybe that list grows over time.
So that's one approach which can be taken. I think it's the wrong approach, in particular when it depends on the circumstance. And I was arguing there are many practices where it depends on the facts on the ground. So therefore, it would be very counterproductive to include them as an additional practice, but rather to say it depends on the particular circumstances. Also, I would like to add that I have picked here a clause where I think that one is in its original form relatively easy to enforce. Once you think about some of those clauses then no longer being spelled out, but just kind of through reputation in a way, supported, things also become more difficult in that context. And then there are other obligations and prohibitions already in 5 and 6, which will be difficult to administer in the first place. So where it's not just the anti-circumvention. So I mentioned self-preferencing. It is not clear how self-preferencing, what is exactly self-preferencing. I do have a proposal there for the Commission how they should do it, but it's also not clear whether they will do it that way. So therefore, I think I would be careful to say that it's just the anti-circumvention part which is more difficult. There's some parts of the initial obligations and prohibitions which are very hard. Also more on the obligation part, which is very hard in practice, will be the interoperability obligations. Because there it's many of those things it's about investment, in a way it's about standards, and so the risk is that the Commission will have to become somewhat of a sector regulator in that area, and currently, at least, it's not well equipped, and there are other risks. Even if it was well equipped in terms of resources, it's not clear whether we would want that way. So so they are important questions, and I think the one very interesting development to see will be, I mean, it's an interaction between the Commission, the relevant parties which are subject to the regulation, and the interested parties which think that they are harmed by certain practices. And we will have to see how confrontational that will be, or whether there are certain elements actually of collaboration. And so that's also something, I guess, we'll have to wait and see how things develop. And yeah, one may be optimistic or pessimistic, but I think that's not my role to express my pessimism or optimism, but rather trying to say what I think of how is the best way moving forward.
So, I have to close this session out, but there will be more time for questions after the time.
And you will have better, more experts at least, and possibly better experts. Thank you.
All right, let's start the panel session. So thank you very much again for attending this policy panel. The topic is similar to the keynote we just heard. I will try to make this panel very conversational. So the topic today, as Martin already explained, is very much at the frontier of both academic research and regulatory practice for regulating digital platforms. Martin has shared with us his pioneering work in the area. We now want to get more input from the panelists, especially from the practitioners' perspective. I will start with a very general question for each of the panelists except Martin. And then after they share their views, Martin can give some comments. All right. Okay. Well, okay. So I have to introduce the panelists, right? So okay. All right. Right. So I will start from the right to the left. So Stephen, okay. Stephen is currently the commissioner at the Productivity Commission and the adjunct professor at Monash Business School. He previously served as a commissioner at the ACCC, as well as the Dean of Faculty of Business and Economics at Monash University. Stephen is one of Australia's top competition economists who has the rare ability to comfortably and persuasively communicate with lawyers, economists, and academic economists. Second, Simon. So Simon is a principal economist at ACCC and is currently on secondment as director in the merger investigation branch. She has been involved in each of the ACCC inquiries into digital platform service. And we are very grateful to Simon because this is not her first time assisting us with panels this year. And then we have Patrick. So Patrick Clark is a partner at the Herbert Smith Freehills. He is an expert in competition law, particularly those related to acquisitions and the merger cases. He has extensive experience advising Australian clients in various sectors, including technologies, media, and telecommunication. Right. The last but not least, Simon. So Simon Muse is a senior partner in Gilbert Tobin Competition, Consumer and Market Regulation Group. He leads the Melbourne competition practice, covering complex merger clearance work, competition litigation, and regulatory matters, with particular regulatory expertise advising across sectors of energy, telecommunication, resources, and transport. All right. So thank you very much for joining the panel. And I will start the general question. All right. So what is your understanding of future-proof regulation, and are there general principles that should guide the design of such regulations? please start with Stephen.
Thanks, Jinxie, and thank you, Martin, by the way, for a really great paper, which I enjoyed reading and I enjoyed the presentation. So how do you future-proof and avoid circumvention? So circumvention is going to be inherent in any regulation. We just don't call it circumvention when we're talking about, say, Section 46 of the Competition and Consumer Act. We call it a breach of the Act. But really, it's the same sort of idea that a business is doing something that you'd hope to prohibit or prevent it from doing through the law. So it's really about, so the different approaches to regulation are really about working out where on a spectrum of regulatory instruments and regulatory design do you want to sit for certain outcomes. And those outcomes relate to the speed of the process, the ability to intervene before harm is done, but also the amount of discretion that is given to the regulator and how much of a check or balance there is on the regulator. So in a sense, you can put the DMA at one end, which I'll call regulator as God model, down to the other end of the spectrum where you're just talking about the Competition Act. And in between, you've got different institutional arrangements. So the DMCC, less of a regulator as God model than the DMA. We've had in Australia, and I'm going to spend most of my time running away from digital platforms because I think we can learn a lot by not thinking about digital platforms, but thinking about other platforms and other technologies. So in Australia, we've had the Australian energy regulator gamed to hell for 20 years and has moved slowly towards the regulator as God model to try and prevent that gaming and circumvention. So the AER is no longer subject to full merits reviews of its decision. Has that led to better regulation? There's probably others who can better say no than I can. The Australian telecommunications regulation, a bit less regulator as God because it's within the communications, it's within the Competition and Consumer Act, Part 11, gamed like hell. And we might be able to mention a few examples, Richard, during the course of the panel. How did we eventually solve it? Well, by nationalising Telstra. We just called it the NBN, and essentially the government bought up all the relevant network and rolled out its fibre network to replace the fixed line network, which Telstra had the monopoly on. I guess that solves gaming if you just buy the company. Payments and the RBA, similar thing. The RBA tried introducing some payments regulation. The first thing that happened was something that Martin didn't cover off on, but gaming or circumvention by the banks, Visa and MasterCard, doing a deal with the company that wasn't covered by the regulation called Amex. And I don't know if you remember those Amex companion cards. My wife does, because we were doing renovations at the time. She managed to put an $80,000 staircase on our Amex companion card, 80,000 points. Of course, all paid by the merchant, which we noticed next time had completely banned any use of Amex companion cards. RBA eventually solved it, but it took time. So these sort of circumventions are always going to happen. You can't avoid them. What then should we do in Australia about this? I think there's two things we should think about for future-proofing, and I think these are ways to future-proof, and I don't think they're the DMA way, and I don't think they're the even DMCC Act way. The first is thinking about the problem and thinking about how it can be solved without ongoing regulation. Mobile number portability did that. You still have to have a regulator there, but you're essentially reducing the regulatory role. Mobile number portability did that for mobile telecommunications. Problem was this massive switching cost. By coming in and changing the rules around the platform, the ACCC still has to have a role, because the first thing that Telstra did was say, oh, it takes us weeks and months to port a number. Let's talk to some engineers. No, it takes you about 50 minutes. Max, actually, it takes you about 1 minute, but let's allow 50 minutes to do it. So you could solve it that way. Very hard to circumvent. we've had similar thing in, well, payments is still an ongoing conversation. We actually recommended at the PC a similar thing for ports. During COVID, the terminal operators in ports are just a platform, by the way. The terminal operators operate on the platform, and they worked out that they could hold containers to ransom and start charging people to pick up containers from the ports. Oops, that's a bit of a problem, particularly when you thought you'd paid for everything. So how could you solve it? You could leave it to the market. In theory, that may solve it. At draft, we recommended that maybe you ban these payments so that if the container terminal operator wants to get a payment for picking up the container, they can do it, but have to actually charge the person who makes the decision as to which port and which container terminal operator to use. I think the ACCC might now actually be having a look at that. I had a call from a commissioner who said, this sounds like one of your ideas, Stephen. So that's future-proofing one. Thinking about the platform and how can you change the transactions to get rid of the problem. Future-proofing two, we have Section 46. I'm sorry, Simone. I always say, where are the cases? You know, all these evil digital platforms, where are the cases? A firm with substantial market power cannot engage in conduct that has the purpose, effect, or likely effect of substantially lessening competition in a market. Doesn't have to be the market where they've got market power. Oh, it's too slow. Goes through the course. Can we speed up Section 46? Maybe we should have a system under Section 46 where we say, oh, the ACCC can seek to have a firm declared to have market power in a market in advance. Remember, Section 46 is now written, separates out the market power from where the harm occurs. So there's no problem with doing that. You can have a process of appeal and so on done in advance. It doesn't have to just be digital platforms. You can do it for Coles and Woolworths as well. Doing that, then if you're worried about speed, going through the courts and the court process is a pain in the rear end. How are we getting around that for mergers? We're going to the tribunal. Maybe we should go to the tribunal for Section 46 cases rather than federal court. But the harm, you know, even if it's 6 months, what about that harm that's occurred? Maybe you should have a rapid injunction process whereby the ACCC can quickly go to the court and say, here's the action that we're going to take for the next 6 months to get a decision on. We want that action stopped now so that no harm has occurred. And the courts are likely to say, yeah, that's a fairly new action. Not going to hurt really the business very much to stop it for 6 months. You can't do it for 6 months until the tribunals, the ACCC member tribunals made a decision of harm. Doesn't have to be digital platform specific and probably solves the problems. Then Simone will tell me.
Hi, so I might have to apologise to Stephen as well. So yes, I'm currently a director in the ACCC's Merger Investigations branch, but I did advise the Digital Platforms branch as an internal economist on many of the digital platform inquiries, and I will talk a bit about our work on that today, but I should mention that I'll be here in my personal capacity. And so I guess maybe I thought I'd start off answering this question just by talking about through those inquiries, we found that these platforms were dynamic. So we've heard the word dynamic used a bit today, and we thought perhaps more so than some of the other industries we looked at. And I think that affects how we think about future-proofing regulation. And so I think when we say dynamic, we could be referring to quite a different number of things. So how particular services may take off rapidly. So for example, we found TikTok's Australian monthly active users jumped from approximately 2 to 10 million in just 2 years. We might be referring to how new offerings are always being developed. Now we always talk about AI, so there are lots of new modern AI systems in existing websites, apps and standalone services. We might be referring to how functionality and the way that services interact can change over short periods of time and can change across regions. And along with that, academics and competition regulators have been considering both novel and existing theories of harm, although I recognise that some may say we're just using existing theories of harm in new context. But I think sort of an example of that from maybe a regulator's perspective is looking at the new US merger guidelines that has a new section on platforms and potential concerns with platform mergers. And then at the same time, we're also seeing things that are sort of relatively static. So Google's search engine market share in Australia has remained relatively high for over a decade. And again, from some of our recent reports, we found that Facebook's Australian monthly active users remained relatively stable, above 20 million for the years between 2019 and 2022. So I guess just sort of reflecting some of the things that we'd observed with respect to these services, we're in an environment where we have some platforms that maintain sort of a static, significant position over long periods of time. But at the same time, there's a great degree of uncertainty and change, and things can happen quickly on a number of levels. And so future-proofing in this context, I guess we've been thinking about it in terms of having regulation that can remain effective in a context with the potential for fast, broad and material changes to services and market conditions. Recognising that Stephen sort of mentioned we might have existing tools that can do that for us. I'll just talk a little bit about how one of our inquiry reports, which was the 5th report in our current digital platform services inquiry, looked at, it recommended a new regulatory regime for digital platform services, which was referred to yesterday. But in that report, there were a few, we called them attributes, that we thought about in terms of guiding our recommendation. And I think these are sort of, in a way, the principles that we looked at, and I think a few of those do go to thinking about future-proofing. And so they were, one was flexibility. So we've talked about this a bit, but in terms of flexibility, one attribute was flexibility, and the report noted that regulation should be sufficiently flexible to enable these timely responses to changes in digital platform services, market dynamics and conduct. Another attribute was being targeted. So it should address specific issues in a proportionate way. In this way, try to minimise potential unintended consequences like negatively impacting the incentives to innovate. But also a targeted approach may enable regulation to better account for relevant market conditions, business models and platform practices that, as we've sort of discussed already quite a bit in this conference, they can change across services over time and also differ across regions. And then another principle we did note was this need for certainty in a way to provide market participants with clear expectations and requirements, to the extent that it can also impact investment decisions. So those were some of the, we call them attributes in the report, but you can think of them as principles that sort of guide thinking about how we might develop regulation that could be future-proof. But of course, they can also come into conflict, which I think has also been mentioned earlier. So measures that may be too flexible can compromise certainty and specificity. And I think, as we probably looked at from overseas jurisdictions, there'll be a need to find a balance between these attributes to implement any of these types of regulations. And I guess just a final remark was that while we set out these attributes to guide our thinking, in the world that we live in, it's probably difficult to think about any regulatory regime that is going to be perfectly future-proof, probably part of what's underlying the debate here today. Things change, and it might actually be pretty difficult to think about how we might develop anything that would be perfectly future-proof. We can't really predict all these future harms and when they might occur and who might do them. And so I guess a personal note is that I think it's probably about being pragmatic and using our economic frameworks, putting the economist hat on here, and the best information we have to guide our thinking and being able to adapt where needed. Thanks.
Yeah, that's working. Great. Look, I think the kinds of principles that Simone was talking about are exactly the right things to be thinking about in the context of, potential ex ante regulation. But as Stephen said, the first thing, and something that I think Australian jurisprudence should be very proud of, is that historically we've used less interventionist means to deal with what have been significant competition problems. You look at Australia and the way that our industries are structured: mining, ports, rail, telco, which didn't exist in any way like the system that does exist when, 50 years ago, when the Australian Competition Act was first contemplated and the core of it put in place, those provisions have primarily operated in a flexible manner, in a way that operated by prohibition and allowed businesses to react and to create, which I think is a core principle that perhaps I think is a very important guiding light to keep an eye on and think about how ex-ante regulation should work. Created the conditions for competition, but don't necessarily require that the success of a provision or the success of an approach is assessed in necessarily the outcome. So I think in the context of ex-ante regulation, there's often a question or a kind of implicit assumption, we should see some of the shares of these digital platforms fall. If that's not happening, then the regulation can't be up to scratch, or it's not interventionist enough, or we haven't put in place rules that are changing the competitive outcomes. That's not the role of regulation. The role of regulation is to make sure that the conditions for competition exist and that specific issues have been identified and then corrected. Now, in the Australian context, we have very strong access regimes, principles that have been applied to various different industries. You could have a debate about whether they've actually been successful in practice, but it was clear that they're dealing with vertical integration concerns, typically making sure that the conditions for competition exist. Those are the kinds of simple principles that I think have had, should be the preference and should be the guiding light in how we're thinking about what ex-ante regulation should do. A second thing that I think's happening in some of the overseas regimes that we're seeing, the DMA regulator has got approach, or even the DMCC approach. That's right in terms of deciding how the regulator is deciding who's going to be regulated, what specifically are they going to be required to do, and they will determine whether that is compliance with the law or not to varying degrees, without necessarily going to a court context, which again, Australia's always historically done, always tested these kinds of things in court. That kind of approach is right. That's what's happening legally, but what is happening in practice, we're seeing in all these regimes, is they are consistently allowing for industry to come to the regulator in some form and obtain some kind of legal comfort as to, if this is what we do, will that be compliance with the law? This is our plan to comply with these particular requirements, and having a dialogue with regulators about this is how we could see this working in our business context without ultimately destroying the value that we've created, the types of revenue streams that we do have that don't seem to have direct relevance to the competitive concern that you're raising. That kind of dialogue, I think, is if we are going to have an ex-ante regime, very important. But from a regulator perspective, there is a suspicion that they're being taken for a ride. I think even the questions in this panel kind of suggest that it's circumvention is the real concern, that a regulator immediately jumps to, that are parliamentary inquiries or MPs or people who are in the public sphere are going to ask, well, why hasn't this been successful? Is it really right that the platforms, for example, the regulated entities were putting forward the solution for this if it hasn't worked in practice? But the concept of circumvention, I think when we come back to circumvention strategies itself, that's not the only thing that's going on. I think lots of these businesses, when they're working out how to engage with regulators, they accept that this is coming, greater regulation is coming. They're trying to come forward with something that will work from a technical perspective, work from an engineering perspective, work from the perspective of how the business generates revenue and brings value to customers as well. So I think that the inherent assumption in kind of circumvention is there is an avoidance going on here. I think there's an acceptance that greater regulation is coming. It's just about finding that right balance between those two. So I guess they're the couple of things that I think are important to think about as principles in this context.
Thanks, Pat, and great presentation, Martin. I really enjoyed it. And I'll come on and I think later talk about circumvention. So I'll share some comments about that a bit later. But in terms of my observations on future-proofing regulation, a couple of things, I suppose, just to make admissions up front. I spent 25 years playing in and around sectoral regulatory regimes across telco and energy, and I act for a port terminal operator or two as well, as Stephen knows. So, and I agree with Stephen that a lot of the lessons for digital platforms are lessons that we've already, in some respects, explored in those other contexts. So I don't think we have to reinvent the wheel. And I think also we can be mindful of some of the pitfalls, which I think I would look at energy and telco as clear examples of that, perhaps for different reasons, though. And the second is that I, over that period, have become deeply distrustful of sectoral regulation and its effectiveness. As a general point of principle, I think in this country we have a tendency to regulate too quickly and too hard. The whack-a-mole type of model, Martin, that you refer to is precisely sometimes how it feels, I think, in regulated sectors. I have a couple of girls, teenage girls, who play netball, and I joke that, you know, if Britain is a nation of shopkeepers, I think Australia is a nation of accountants and netball administrators. And that certainly in some of these markets feels the way it is. And what does all that have to do then to future-proofing regulation and how I think about that? Well, I think the first thing is to be very clear about your objectives. What are your policy objectives in the first place? Because you can think about future-proofing in terms of how do I make sure that my regulation, as I've drafted it, continues to operate as technology changes. That's one way to think about future-proofing. Or do you mean by future-proofing that I've got a regime that is throughout a period of time able to doesn't like me, a particular type of policy outcome. And if I go back to sort of telco 25 years ago, and you think, and Stephen's already gone to this, you know, we were facing a similar situation where there was a very stable, technological neutrality was a central principle, as Richard will recall, of telco regulation for many, many years. And the idea being that the same regulatory model should apply irrespective of the type of telco network that you operated. That was a kind of underlying principle. But of course, it never worked in practice, because fundamentally to actually regulate a telco network, you have to regulate a technology, and you have to be specific about how you're going to do that. And so, you know, in the years of local loop unbundling, for those that are old enough to remember those debates, that was all about trying to open up, interoperate, and create access at the deepest point in the network you could. It's Martin Cave, it was ladder of investment, it was all those kind of principles and those theories. What it was really about was sweating existing assets, taking existing telco networks that had already been built and that were sunk costs, and sweating that value and sharing it amongst a bunch of arbitrage taking entrants. That's effectively what that model was about. And it worked fine for as long as you had those networks. But when you wanted fundamental market shifting investment in fibre and in an ultra fibre network, when you wanted to actually have a step change in the market, that regulation was wholly inadequate, didn't work, could not create that environment for innovation and investment. And consequently, when I was working in Europe 20 years ago, they were having very similar debates, rewriting their telco framework, their communications regulatory framework, precisely because it wasn't delivering, the existing framework was not delivering investment and innovation. And so one of the concerns I have with the digital platforms debate is it has a resonance to me of that. What's happened is we've got a number of very large players who have built very big businesses that create a framework or create an asset that now is there to be sweated by regulators in a way, and that's fine, and that's a legitimate regulatory objective. But we also have to acknowledge that, as we've learned in previous network industries, that model will also impact investment and innovation in terms of the new development of those sort of networks moving forward. So that's rather an unpopular thing to say up front. It's also, though, I think, borne out, though, and I do this every year, I jump onto PwC and I look at the global capitalisation numbers of firms. And of the top 100 firms, it's no surprise that 18 of those are US firms. Of the top 100, 18 are effectively defined as IT or telco, or not telco, technology firms, of which 13 are US. I think only 3 were European, Accenture and SAP, and the chipmaker ASML, and the rest came from the rest of the world. So the heavy emphasis on sectoral regulation, and I'm not blaming regulation entirely for that, but there's no doubt in my mind that the complexity and the weight of regulation in Europe does impact on the level of capital investment and innovation. And if I look in the energy market, I see it as well. If I look at a mobile, if you take I think Stephen's example of mobile is a great one. You look at number portability and mobile termination. Regulating mobile termination charges and number portability, effectively, that is about all the economic regulation of mobile networks we've had, and we've had immense amounts of investment. We haven't had to have governments nationalising the mobile networks in order to get these things to be invested. And billions of dollars have been sunk into extensive, almost 100% coverage now across those 3 competing networks, including innovation around mock-ins and these sorts of things. Spectrum's a scarce resource, so it's slightly different. But we've been fairly light touch with competition rules. Some would say we haven't been light touch enough. But if you're talking about kind of competition rules that overlay and pick winners in terms of who gets what kind of spectrum, I don't think we've been as heavy-handed as other parts of the world. Yeah, here in Australia. Similarly, in energy, one looks at heavily regulated, sectorally regulated parts of the network. Removing limited merits review, if people think that that's been a success and we've seen the investment in transmission and we've seen the investment in our distribution networks that we now need being driven by that framework, then they're not reading the same papers or looking at the same kind of outcomes that I'm looking at. So that's my rather strongly worded response on this. I think, what does that mean for guiding principles for being future-proof? My suggestion is we should be slow to regulate. Ex-ante regulation assumes a problem. It's very, very hard to do effectively in the midst of a highly dynamic, constantly moving environment, and you do run the risk of inadvertent consequences. You need to appreciate that every time you put regulation in place, you are affecting investment and you're affecting business models. That's what we've heard today. Now, that can be positive. It may have a positive outcome, but don't assume it'll be a positive outcome. Be very clear about what you want to do. I think there's sometimes a blurring in digital platforms debates between consumer protection issues and competition policy outcomes. I think you need to be very clear in your mind, am I regulating for consumer protection issues or am I regulating for competition policy? And even the European notion of fairness, I think, is a very difficult one to operationalize on the ground in competitive markets. It's not my job as a competitor to give my competitor a fair go. It's my job to beat them in the market, to have a better product, to offer a lower price, to be more innovative. They will be harmed. They will lose market share. It will hurt them. But that's my job as a competitor, not some sort of Australian fair go, fairness type ethos. I think we have to be careful about politics and knee-jerk reactions. And finally, rather cheekily, I would observe, I think when we do regulate, we should do less than half what the EU does and a little bit more than the Republicans want.
Well, I guess economists often think about what would be the best thing, and I think that's in this debate not very useful, especially not in Europe, perhaps in Australia on a better path. What we need to look at when we talk about what kind of regulation, if any, I think is to think what is the counterfactual. And in Europe, I see the counterfactual to something. It doesn't need to be the DMA, but some of that framework. The alternative is piecemeal, idiosyncratic, incoherent interventions by different legislators, meaning different member states. So therefore, I think not necessarily the DMA, but something had to be done. It could have been a more powerful market investigation tool, which I was advocating. But I don't think the question really is we can just deal with standard competition tools and wait, because there won't be a waiting, at least not in Europe. There would be other interventions. So I'm not sure, perhaps in Australia it's different. Then you can have that debate. But in Europe, I think we also had that debate, but I don't find it very meaningful because this is not what would be the counterfactual. Okay. Learning from other sectors, well taken. I think some issues are there. What do we really learn? I don't know. In most of those sectors, a large part of the regulation was price regulation, which in a way is much easier. Of course, we did have some kind of, in a way, circumvention strategies there. And once you got the prices regulated, you could try to deal with non-price aspects, but much less than in digital. What is the consequence of that? It's not clear. On the one hand, it becomes harder to regulate. On the other hand, you can say there's also more of a need to have saturation. So I don't know what is the consequence of it, but I think we shouldn't get too far with these parallels of past regulations, say in telecoms, which I also have been following. And then, and we can discuss, of course, telecom regulation, but I don't think that's the purpose here. We're looking at the future and less at the past. And I think one of the big open questions, which I also didn't address, which the DMA doesn't really address, even if we just think about competition, which in the European wording would be more the kind of contestability part. What are we talking about? What are we imagining? These markets are very different. So first of all, we have to understand, in some markets, are there actually natural monopolies? And that's debatable. And the second one, even if there are natural monopolies, can we live well with them if they're only temporary and we manage to have this kind of competition for the market? I think this is very important. I think many of the digital markets shouldn't be put in the same box. They're of different sorts. And I think some of the criticism even by some of the big tech players is correct. The conclusions they draw, I'm not sharing them necessarily, but I think some of the points are very important, and therefore it is not really very operational of what we mean with contestability. And the way the DMA, I think, works, it's mostly looking at contestability in adjacent markets, which is definitely one way to look at it, but it's much less ambitious in a way than what could be the way to think about the right policy approach, which is to have to enable competitive threats to emerge and be successful if the offer is better.
All right. The next question is, so it has two parts. So the first part is about sort of the approach ACCC proposed in their digital platform investigations. So I want to direct that question to Simon. And then the second part of the question is making comparisons with those approaches taken by other jurisdictions. I will invite other panelists to join. So first question to Simon. So have the ACCC inquiries into digital platforms identify specific circumventing strategies employed by platforms, and what future-proof measures have been proposed?
Thanks, Cheng-Si. So I was going to start this, my response to this, just providing a quick overview of the ACCC's work, just for people who, although I suspect most people here know quite a bit of that. But the ACCC started examining digital platform markets back in 2017, and this was initially as part of the Digital Platforms Inquiry. And in that inquiry, it looked particularly at online search engines, social media services, and digital content aggregators. And the final report for that was published in 2019. Then the ACCC undertook another inquiry in respect of digital advertising services called the AdTech Inquiry, and the final report for that was published in 2021. And currently the ACCC is conducting a 5-year inquiry called the Digital Platform Services Inquiry. And that concludes in March next year. So they're 3 separate inquiries, although quite a number of reports. And this 5-year inquiry requires us to provide reports to the Treasurer every 6 months, and there 8 of them, I think, potentially have been published, at least 7. And so quite a few of the earlier reports looked at individual services, focusing on the competition and consumer issues in respect of those services. And some of the more recent reports have been thematic. So as I'll talk a little bit about soon, the 5th report of this inquiry was on regulatory reform. And the other thematic report we've done recently is our 7th report on expanding ecosystems in digital platform markets in Australia. And I thought I'd just quickly mention my colleagues are currently working on the final report, which will be submitted to the Treasurer in March next year. It'll consider 3 topics, but one of those is the on international regulatory developments. And it intends to explore what has happened in overseas jurisdictions who have implemented these new ex-ante regimes for digital platform services, and where possible, it'll consider the impact that it may have already had on competition and consumers. And then to the second bit of your question, Ching-Hsi, on whether the inquiry state have identified specific circumvention strategies employed by platforms and what future-proof measures have been proposed. I think the best way for me to talk about that question is to talk about the work that we did as part of the report on regulatory reform. And recognising comments that were made sort of earlier, that in that report we did look at our current laws, and we did consider that they were not particularly well suited for addressing the range of conduct that we had observed been engaged by platforms to date. Some of the concerns we had were around the time it might take to address those concerning conducts through our current system. So understanding what Stephen's already mentioned, I think some of this was discussed at yesterday's panel. So I was mainly going to just make reference to actually some of the concerns that were raised in respect of circumvention. And so an example that we put in our fifth report was actually with reference to the former inquiry, the AdTech inquiry. In that inquiry, we raised concerns that Google had engaged in multiple different types of self-preferencing conduct over time, and noted that it had the cumulative effect of lessening competition in ad tech services. And that included various restrictions on how some of their own services worked with third-party services across multiple interrelated ad tech services at different levels of the supply chain. And as most people here would probably be aware, multiple other jurisdictions have had similar concerns. And so I guess in relation to sort of circumvention strategies, I guess that's sort of a more specific example. And then in our regulatory report, we noted that the enforcement of traditional competition and consumer laws may not adequately address those types of concerns. And it could be the case that there's one instance of conduct that ceases due to enforcement activity if we have success. But what might happen subsequent to that is that the platform then adapts its practices to achieve the same outcome, but with different conduct. So it may be possible to circumvent specific conduct. And the report noted that in that case, the platform may subsequently evade detection, or the regulator may be required to bring a new case on different facts, which would again take more time and resources. And so, as you well know, in that fifth report, we made recommendations for new competition measures for digital platforms. And as part of that, we did take this concern, this issue about patterns of behaviour and circumvention into consideration. And I guess reflecting on that report, I'd probably say that addressing potential circumvention is in some ways embodied across multiple elements of the recommendation. And maybe just to say that I think, maybe Rod said yesterday, there are some similarities between our recommendation and the UK's approach. So some of what I might say might reflect some of that as well. But our recommendation was for mandatory codes of conduct for designated digital platforms. These codes would be service specific, so would be for a single type of digital platform service. For example, search engine services, there might be a code just for those services in themselves. And the codes would support targeted obligations, which would be guided by high-level legislated principles. And I'll talk a bit about each of some of these elements and how they go to future-proofing and considering potential future circumvention. So on the high-level principles, and I think we have touched on this a bit today as well, we noted that the principles, we noted high-level principles in legislation should establish the scope and guide the design of each code's obligations. One example of that is that we've recommended that the principles should promote competition on the merits, or in other words, promote competition by addressing conduct that hinders the ability of rival firms to compete. And so we can probably debate, what those principles should be, but I think the point that I guess I'm trying to make is that having an overarching principle to guide code design may go some way to addressing those potential circumvention strategies. Because if you have a high-level principle guiding the code, it means that the codes should overall be capable of trying to achieve that outcome. And then in terms of the codes and obligations themselves, the report recommended that they should be able to support targeted obligations to address certain categories of conduct. And these categories, there's quite a long list, so just a few so that you know kind of what I'm talking about. Anti-competitive self-preferencing was one, anti-competitive tying was another. There was also discussion of impediments to consumer switching and exclusivity and price parity clauses. And the report does go into more detail discussing the specific examples of where our inquiry work had at that time raised competition concerns in relation to each of these categories of conduct. And it provided indicative examples of the kinds of obligations that new service-specific codes could potentially include, noting, of course, that, and maybe going to Patrick's point, that the final code development would involve further detailed consideration and a lot of consultations. That was recognised. But in those indicative examples, they did raise in some circumstances how the codes could consider multiple different obligations in conjunction in order to prevent narrow compliance or easy circumvention. So, for example, in relation to anti-competitive tying, the report noted the ACCC was concerned about tying that had anti-competitive impacts, of course, and it discussed some concerns more specifically with Apple's requiring their own in-app payment systems to be used for certain payments made via the apps download from the App Store. And the concern was that this tying could reduce consumer choice, both as consumers and developers are unable to use other payment systems for making certain payments in apps. And this could potentially negatively impact the quality and functionality of apps where alternative providers may offer better suited solutions. Sorry. And the report explains that this could be addressed with, you know, a specific prohibition on such tying, but it also noted that it will be important to develop a code to prevent narrow compliance or easy circumvention that may undercut the intended effect. And so in that example, the intended effect, I think, relates to promoting consumer and app developer choice for payment systems. So in addition to a prohibition on tying, it may be important to consider other practices at the same time that may disincentivise app developers from using alternative payment systems, or practices that might hinder the ability of other payment system providers to compete. And so that could be things like unfavourable or discriminatory treatment, price parity clauses, or exclusivity agreements to business users that choose to use alternative third-party providers. And as discussed in Martin's presentation, these things might be sort of very context specific. So the report didn't necessarily go into that, but just introduce the concept that in developing a code, one might consider how these different obligations would interact and how they might go to addressing some potential circumvention issues. And then I'll just briefly mention a couple of other elements that were noted as part of the potential future framework. And they would go to support some of those attributes being flexible and adaptable regime, so that the codes should be periodically reviewed to ensure they're achieving the intended outcomes, and it should be possible to amend the obligations in the codes over time to the extent that the nature of the harmful conduct changes. It noted that having service-specific codes would allow the tailoring of obligations to issues relevant to the services as they change over time. So we've mentioned different business models and different types of activities that might be the ones that are issued in a particular context. There's also the question of the list of services and the definitions that go with that might need changing over time, particularly if new services come into the field that need to be considered. And it also notes the importance of the relevant regulator having the ability to collect the relevant information and data to actually investigate compliance. And then I think it was also mentioned yesterday, another thing that may be important is for the relevant regulator to be able to perform monitoring and reporting functions, so to actually have the capacity to build knowledge and understand what's happening in the market separate to their particular enforcement activities to make sure that the regime remains fit for purpose. So that's sort of quite a few elements that don't maybe goes to a specific example of circumvention strategies, but how the proposed framework has multiple elements that sort of go to thinking about addressing those in future.
Thank you, Simon. So the second part of the question is, so based on Simon's explanation of the proposed approach by ICCC, so what can you see as the main difference between the approach between EU, the CMA, and what would be, I mean, in addressing the circumventing strategies, and what are the underlying rationales for the difference? So I'll probably start with Martin.
I always want to have the last word, not the first word. So, I mean, the current landscape, I was quickly talking about it, is how close you are with standard competition law practice, while still there is an element of ex ante part in there, as it is in the UK. Or Germany, versus moving towards a more standard regulatory framework as it was done in the EU or with the DMA. And I think what is best also depends a little bit of what else is to be expected. If you are just working, say, with a UK regime, and then you still get the legislator intervening repeatedly, you may not feel very happy about that outcome either. So I think so I think it's a little bit the overall landscape which matters in terms of the choice. Otherwise, I have very, very clear preference for the UK or the German version of it compared to the EU version. And the other point I think I already mentioned, I want to make it again, it depends on the other competition tools which you have available. And perhaps if you see a deficiency, perhaps think also about those other tools first, rather than a sector solution, and do think whether a market investigation tool based on the UK model is something you want, because in the end, you will have to look at these different digital markets separately. They are very different, and therefore it's not clear to me. There's always this idea, oh, we are building up general competence in digital markets. What is this general competence if each company and if these markets are operating very differently? So you build up perhaps competence on how EdTech works in the Google world, but that's then this part, and it doesn't tell you much about some other important digital activities, for example, e-commerce platforms and the link between data and logistics, for example. It seems like a very different thing to talk about. So therefore, I do see that there is a need for an authority, call it a competition authority or a regulator, to understand those markets. But it's not clear that there's that much transfer of knowledge when you know one, that you know the other. And I think that's very important. Therefore, that speaks, I think, very much in favor of having some kind of market investigation tools available. In which way they are kind of cooperative or confrontational or not. I mean, that's you can then, that's another decision to make. But it's, I think there, Stephen perhaps would agree. I mean, it's not digital or not digital. Why do we look at digital? Well, because I think it's difficult to find other companies which play such an important role in the way they shape the fortunes of some small businesses, and in which they affect our kind of life experience, if you want. And I think, therefore, there is a good reason to dedicate some thinking and some resources on those. Don't put it under the label of digital, but think of it as very important services we care about, which are currently not publicly owned, but are provided on a for-profit basis. And I think one important element in the whole discussion that applies to competition law, but also to these to new regulatory tools, is what kind of, if at all, and how easy it is to use interim measures. I think that's very important in those fast-moving markets. Interim measures, I mean, it's a two-sided sword. It can be really horrible to have very strong interim measures, which in a way kill innovation. So you don't want to have these interim measures. But if you have interventions which need to be timely and where the legal process takes its time, so yeah, you may need interim measures not to end up in a market structure which is very difficult to reverse. So I think there's a big tension, but I think there's an important discussion if you do a specific regulation or if you sharpen the competition, the existing competition law tools, is the role of interim measures.
Other panelists, feel free to jump.
Yeah, so I largely agree with the comments that Martin just made. So compared to others overseas, I don't know enough about the DMA or the DMCC to comment on that, but I did hear yesterday somebody saying, we're too slow in Australia. They're doing it overseas. We've got to be there. And I won't call this the whack-a-mole strategy. I'll refer to another little furry creature. I'll call it the lemming strategy. You know, damn, we're too slow going over that cliff. The other lemmings are ahead of us. I'd sort of like to know where we're heading. And I think Martin's exactly right. And it's why I really have a problem with things like digital regulation, because they're all different and different. We're not talking about a market. We're talking about a whole range of completely different markets and different technologies. And that's why I really think that we do need to learn, you know, I like the approach of saying, look, have a general rule, which is why I sort of say, hey, can't we just get Section 46 working, plus specific, you know, interventions, careful interventions on top of that. Because that's what we've sort of seen work in other areas. And we should be learning from other areas because quite frankly, you know, if Simone mentioned the Apple App Store, if I look at the Apple App Store and I want the closest parallel, I'll look at ATMs. It's a completely different technology, but exactly the same economic problem. Remember foreign fees at ATMs. You'd go to an ATM that wasn't associated with your bank. You'd take out your, let's say, $100, and unbeknown to you, there's this $5 charge that you only see at the end of a month on a statement. Completely unclear who's getting what money in there and what it's costing you. So how did we solve that in Australia? The RBA came along and simply said, we're going to make it transparent. So we're going to have a rule that, of course, you can charge a foreign ATM fee, but when you do it, you've got to make it clear to the customer when they withdraw the money. You've got to give them the option of not continuing with the transaction. And what was the end result? After about 6 months, all of the foreign ATM fees disappeared because the customers said to their bank, what the hell, I'm paying $5 to do this. Actually, the prices went down compared to what the customer had been paying, but all of a sudden the customer was aware of it. Apple App Store. My starting point on that would be to say, if Apple wants to charge 30% because it's done it from day one, that's fine. It just can't hide it. So when you go to Apple App Store, how about you say, this is going to cost you $5 or whatever the app is. Oh, plus, are you happy to pay the Apple fee of whatever 30%? I should have chosen $6, shouldn't I? So I could do of $1 something as 30% of $5. You know, do you wish to continue? Yes or no? I don't think it would take very long before Apple customers would say, what the, whoever's running Apple now, where's this fee coming from, and start to put pressure. It may or may not solve a problem, but it's an easy way. It's just price transparency. Maybe you have to go further than that, but it's not a bad place to start. I like transparency. So you can learn that from other sectors. What else did we have? On the ACCC approach, yeah, if we've got to regulate this sector, mandatory codes, it is specific to the individual market, hopefully. We've seen codes being successful in groceries. Okay. Maybe not. I prefer the DMCC Act type approach than the DMA type of act. And maybe it allows for more dynamic approach, particularly to circumvention and to new technology. I'd like to see time limits on these things at least, though. So, okay, you're going to be under this mandatory code for 5 years, and then we're going to review the whole thing just to check, do you guys still have market power, or has it disappeared? Final point, though, I'd like to mention is on international regulation, and maybe the US election has changed this, because I don't think we're going to have a US version of the DMA anytime soon. But we are a regulatory taker here in Australia, and we do have to allow for the fact that if we go out of line with the major regulations on digital platforms, these are international firms. We are a pimple at the bottom of the world in terms of their demand. And it's quite possible some of them will say, stuff Australia, and not bother if we simply put on regulatory constraints that are inconsistent with the rest of the world. That doesn't mean we have to regulate, but if we are going to regulate, let's think about, okay, what do the businesses already have to do? What are the international standards? And then think hard before we have inconsistent domestic standards. And that's, again, not just for digital platforms, that's across a whole bunch of industries.
I'm happy to go next. Just looking, we're going down the line again. Yeah, so I think Stephen might have shown a bit of optimism towards, or maybe not, I read that wrong, towards the ACCC approach. I think maybe just in terms of, so the question I think from Cheng Si was looking at how the approaches to the DMA and the UK's DMCC differ to the in what we have in Australia. And I think my sort of initial reaction to that was that they're obviously much more advanced than us, and we don't really have something in place to consider. We have sort of the recommendation that the ACCC made in their report, which we understand the government has sort of accepted in principle is looking at. But the DMA, is currently entered into force. We've got something we can look at, observe and study and react to. The UK government passed their DMCC Act earlier this year. And I think draft guidance has already been consulted on. So there's a lot more sort of concrete in there to look at and to react to. And while, some of us might be sort of eager to go in Australia with regulation, we are in a position where, as I mentioned, our 10th report will actually look at some of these international developments. So there's an ability for us to actually observe and learn from what's happened overseas. So I think maybe that's sort of one thing to comment on. Another thing is that we have sort of, as people have mentioned, sort of the ACCC's recommended approach looks a little bit more like the UK's approach than the DMA. So just to draw some parallels, the ACCC's approach was for service-specific codes for designated platforms, and where the codes would contain some high-level targeted obligations. And where this looks a bit similar to the UK's approach is that the UK's approach is again for designated firms, so SMS firms, in respect of a digital activity, where there can be conduct requirements for those firms and also pro-competitive interventions. And those conduct requirements are guided by some high-level objectives in the Act. So they have fair dealing, open choices, and trust and transparency. So that's where those sort of some similarities that I see between the two. And it looks quite a bit different to the DMA approach, which requires designated gatekeepers to adhere to quite a broad list of obligations and prohibitions. And these were set out quite early on, and those are not service specific in some ways, in most ways. Although I think where a similarity may arise is that sort of as was sort of discussed in Martin's presentation, there may be a process by which even through the DMA, we may see some targeted obligations in future. Because I understand that they have, the European Commission can investigate non-compliance and may have the ability to impose additional behavioural and structural remedies to ensure compliance. So that's where you might see more specific obligations apply. And I think that maybe just to comment on some of the other points that have been made, that I think that the proposed approach from the ACCC does look to, as I've mentioned, have very more targeted obligations in place to address specific issues. And we don't really have something in place to look at, but I think some of the concerns that have been mentioned to date, this type of approach would in some ways go towards thinking about what might be the best way to improve competition in some of these sectors, which are services which are really important to Australians. So it's not, it's actually, I think, hard to debate at the moment and critique what could otherwise happen, because we're still in the process of sort of finding that out. So I think some of the discussion can actually help inform what might be the best approach going forwards. And I think as well that one of the intentions is to promote competition and to promote innovation. And I think to Martin's point as well, we have to think about what is the counterfactual, what is the counterfactual of doing nothing as well. Like, this is quite complicated. So we want all the best thinkers in the room to kind of figure out the best approach, but is the best approach doing nothing? And I think the ACCC sort of put forward their recommendation that's sort of one place to start. So that's probably what I might say on that last question. Thanks.
I thought I might make a couple of comments. Actually, just picking up on one of the points that you made around the public nature of processes being perhaps one of the factors that's important around how effective they are, and also how they're successful in adapting over time. I was thinking earlier in the week around the government's one of many consultations that are currently going on around the regulation of AI, and whether the Australian consumer law remains fit for purpose in that context. There's, in my view, a very extensive focus on consumer guarantees and other things that are kind of second and third order concerns. But one of the core things that occurred to me in thinking about that is one of the most simple provisions that exists in our competition and consumer law is the prohibition on misleading conduct. That effectively businesses in their dealings with consumers, other businesses, everything else, everyone will be subject to the standard that they not mislead the counterparty. That provision has not changed in a very long time, and yet it remains, from an ACCC perspective, I think one of the most successful tools against not just digital platforms, but also a range of other, industries that are also characterized by parties that have very strong positions, supermarkets, airlines, they've all been in the news recently. The ACCC has achieved some very successful enforcement outcomes there, and also private parties as well. One of the features that I think is relevant to that is how public that, it's regulating public conduct, although it's also regulating private conduct as well. But if you were bringing a case around, there's been cases around how disclosures are made to consumers as to, what's going to be done with their data and the number of choice screens, for example. But there'll also be otherwise private contractual negotiations. The ACL, and particularly the prohibition on misleading conduct, is relevant to those, but it will be ventilated in court as to what's been said. Now, certainly in the marketing context, when you're dealing with consumers, I can't think of a group of people who are more employed by businesses to effectively put across an attractive proposition to customers. And while fine, if we can't say exactly that, can we say something that's very like it? What if I put green or teal or blue, and we're constantly advising on those kinds of things in areas of grey, but the standard and what is required is constantly moving. The public nature of that means that with the benefit of kind of advice, even with very, very sophisticated, circumvention strategies, if you take that approach to it, there is a self-executing, self-changing process that takes place there that changes how businesses are going to interact with consumers. And I think that's one of the features that's relevant to thinking about, particularly, if we think about codes now in the context of ex ante regulation, it seems from the panel there's kind of an acceptance that if we go down the path in Australia of having specific codes, they're not just going to be sector specific now, they're going to be service specific. They're going to have to take into account, privacy of user data, how exactly interoperability might work in particular data sets, how these things are organized. They're going to be very, very targeted. One of the anti-circumvention strategies that comes across, expecting what the ACCC would expect, dealing with undertakings and other sector-specific regulatory regimes, there is always reporting. It is commonly to the ACCC, sometimes only on a confidential basis. There's sometimes public reporting of compliance, which we do see in some sectors. But I think that process is likely to be a feature that the ACCC would see as key to making sure that these specific regimes are effective in assessing whether they've been complied with or not over time, the extent to which publication about compliance is done, or there are reporting requirements. I think is going to be core to whether there's whether circumvention, there are effective means to deal with circumvention. The only other point I just wanted to make is because of how our how our legal system works, we're historically quite different to the European context, which when I practiced there, I was really struck by the powers of the European Commission, the way that their legal system works, but also the certainty that can be given by the European Commission and its various DGs as to whether you are compliant or not. That is something that at least companies can rely on. That is not the case under our regime typically, because it's typically backed by court enforceable outcomes. So the ACCC can issue guidance, but it has no status under our usual laws. If that's going to change in terms of companies agreeing, well, this is the issue as we understand it, this is the kind of conduct we propose to engage in, can you back us? Will we now be immune from prosecution or being found to have contravened these codes? How that balance is set, I think, is going to be very important to how effective it is, and therefore whether these kind of things that could be it'll be clear whether it's circumvention or not, I guess, or whether it's problematic circumvention or not. That'll be quite important. But the nature, I think, of what's being proposed by the ACCC, and I don't think this has really been fully admitted to in the papers that the ACCC has put forward, what necessarily flows for our regime is they will require that there is a broad power to create codes. There's a broad power to determine the content of the codes. There's a broad power to determine whether you've complied with the codes or not. Some of that basics will be in legislation. Some of it will be in regulation as to what's permitted and not, but a lot of it is going to have to be in the ACCC's hands. It's a fundamental shift in determining what those standards are than what we've historically done. And I think given that there is the risk of over-regulation, there is the risk of solving problems that are not real problems, or solving problems that are mixed consumer competition problems. There's a risk of lack of specificity in that. So I think all of that is just something inherent in the regime that really we should be thinking about when we're thinking about circumvention strategies. Is our response to potential for circumvention actually going to lead to a regime that is actually very hard for companies to get certainty around, and for the risk of overregulation quite strong?
A lot has already been said. I think I probably don't share Pat's view on just a couple of the observations he's made. I think it's premature to understand quite how the code system's going to work, because, of course, we've only seen the report. It's stuck in political purgatory right now, so we're not quite sure what ultimately is going to come out the other end of that. I do have a general observation, which I started with respect to the ACCC process around those codes. I do think there's a blurring of consumer and competition policy objectives in those documents and in those reports, and I think that will be problematic. I think consumer issues and the operation of consumer protection, whilst I understand that there's an alignment there, I do see that as a different set of objectives, policy objectives, to the economic objectives of facilitating or overcoming market failure and facilitating competition in markets. Excuse me. So the first thing I'd say about the codes, I would hate to be in a world where we had a set of codes in digital platforms which required our friends to have to pick up the phone to the regulator every other week to ask whether some new pricing construct that they've got does or doesn't step on the right or wrong side of some defined term. Because, and I think the point was made in a question Stephen made at the start, you know, one person's price discrimination is another person's Ramsey pricing, highly efficient, price differentiation, quite appropriate, what you'd want to see in a well-functioning market. If you've got to pick up the phone and speak to the ACCC every time you want to have a differentiated price structure, then this is going to seize up the kind of dynamics we want to see in markets. And as someone who in my time has drafted a number of access regimes from telco through ports through everywhere else, what you end up with, if you want to be truly equivalent and avoid the risk of, and I don't even like the term circumvention. I just think it just sounds like we're trying to trap naughty kids at the back of the classroom. But you end up with a rate card. It's rigid. You can't differentiate between customers. You can't really develop your products effectively because you're so constrained. You have a set of standard products and a rate card of set of prices, and you can be certain that you're going to be compliant. And if that's the world if that's ultimately what we all think we need in these digital markets, then that's I'm concerned that's where you head toward. So I think there's another question about anti-circumvention. We'll talk about 46 because I think that's the answer. But that's my main observation. I do prefer the UK model to the European model. I think this idea of having a broad effects-based analysis as a sort of circumvention tool is deeply problematic. I sit here thinking, I thought that these these code structures were so that we could assume market power and move straight to dealing with specific types of conduct. I didn't know that it was about assuming effects of particular types of conduct. If it's about assuming effects, then that's a very different that's a different and more problematic world. I think we have a mechanism for saying you've got market power, you've engaged in conduct, and it's having an anti-competitive effect. If you have to do that in a very market-specific context, which is what I'm hearing, then I don't know why we're worrying about it in a code. I think we should be dealing with it through the existing Section 46 process. I'll come on and talk about that a little bit more in a second, but they would be my observations. I'd also just make the point, whilst it's not happening in codes, we are not slow in racing away with regulation in this space. I just flicked through the chronology of the last 4 or 5 years, and there was of course, there was a media bargaining code. There's the DPSI process that we've been through. There's an unfair conduct prohibition we've heard announcements about, which will focus on online behaviours around dark patterns. Merger reform is squarely aimed at the digital platform. I know Annalisa and Marcus have spent lots of time cooking up a regime that makes sure we capture killer acquisitions and other online deals. Consumer data right and data portability. What we're hearing, and I was listening to Philip Marsden at a speak last week about this, and his observation was we need to open up these platforms using those tools. We're not about breaking them up, and I think that's a really important observation in terms of the way the UK are thinking about this. And one of the concerns you have is that where you've got highly detailed forensic processes like consumer data rights with endless loops and bundled consumer consents, you actually make it very hard, not for the big players who can afford a regulatory team of 300 to deal with those processes. You make it hard for fintechs and innovation around the edges. And actually, I can tell you, because I mainly work with incumbents by and large don't mind complex regulation. They operate in those worlds every day, and it tends to actually assist them. They pay very expensive, overpaid lawyers to help them navigate those regimes. It tends to be the smaller and medium-sized innovative players that find it harder. And in digital platforms, I think that's a particular concern. Misinformation Act, privacy reform's a mess. And then yesterday we heard about the Online Safety Act to introduce a digital duty of care. So no one should think that there's not regulation hitting this sector at a rate of knots. There's a lot of it. It's covering a wide range of issues. And this is just sort of one aspect of that.
Thank you. Thank you very much. I still have 1.5 questions on my rundown, but we are terribly behind our schedule. So I probably just I also want to give time to the audience. So let's just open the floor for taking questions. All right.
Can I just make one observation on section 46? Because I can't leave without doing this. I actually, it's to agree with Stephen. Section 46 does work in these markets. Now everyone sort of rolls their eyes and says we haven't seen the ACCC bring a case, and that's because we haven't seen the ACCC bring a case. But there are at least 14 or 15 section 46 cases in the last 5 years since the effects test was introduced. That's a significant number of cases, far more than we had in the 5 or 10 years before that. So 46 is being used, and it's being used more. It's just not being used by the Commission. And of those cases, a significant number are digital cases. They're online cases. And in a significant number of those, we've seen injunctions granted that offer short-term urgent interim relief. So unlocked in Google, private case, bought in 2018, interim injunction was granted. Dialogue and Instagram, social media, a case involved Meta and Instagram kicking out Dialogue for scraping. Again, an injunction was granted. That was 4 years ago, still in place. So, you had interim injunctive relief. Epic and Apple, Epic and Google. We've seen Sony. We've seen a number of these cases brought. We've seen investigations by the Commission in relation to revenue sharing under Section 46, and we've seen 87Bs agreed with Telstra, TPG and Optus to prevent that conduct with Google moving forward. So I do just want to say, if we're talking about anti-circumvention, if that's the right way, and I don't like that term, but if that's the term you want to think about, 46 is not sitting there a dead letter. I know people say it takes too long, it's too hard, we can't get documents, but private litigation is regularly achieving outcomes, and quite urgent outcomes at times, including in the digital space.
Can I just ask you a question then? Thanks for it. So that's the trouble. You guys haven't asked questions, so I'm going to. So Simon, you can't get authorization under Section 46, I think, at the moment. Hope I've got that right. I'm not a lawyer.
You can.
Oh,
since 2017, you can. Yeah, that's right. Yeah, that's right. Yes, you can.
Okay, so a digital platform could go to the ACCC and say, I want to have this.
If you want to go through 6 months and a public process, and but you could.
But if you want the certainty, you can.
You could do it. Yeah.
Okay.
But I mean, the challenge with authorization in a highly fast-moving competitive environment is I've got to go out to the market and say to my competitors, this is what I'm about to do. I want to do it in 6 months' time after the ACCC has had an opportunity to consult publicly on it, by which point is it still the strategy you want to adopt?
Actually, I think it raises a really important that we probably haven't touched on in this discussion, which is reactions of others in the market, reactions of competitors, potential competitors, rivals. They're going to be taken into account in an ACCC authorization context for 46, and probably those concerns are going to be heard fairly loudly, I would have thought. And the ACCC is being asked to do something that it doesn't have to if it's not satisfied. So there's that kind of legal test. But if you move into an ex ante regime, the discussion is not just with the party who's engaging in the conduct, but there is always a discussion with the people who are on the other end of the now reconfigured pipe, who's supposed to be receiving this data. Oh, no, we don't want it that way. We want it this way. It won't work if we have it like this. That would be expensive to do it. Those kinds of concerns that are raised by rivals will inherently be important. There's going to be more of them to start with in terms of voices, and they will be important in whether a regulator's assessing that this particular ex ante intervention is likely to be successful or not. So I'm not saying, as Simon said, the companies that are potentially regulated don't have strong voices to put their views on what would be effective or not, but there'll be a balancing, and that assessment in a Section 46 context is made by a court with admissible evidence and a whole range of other protections around it for both sides. In a decision or a discussion in a room with the regulator as to how should this be framed, how exactly should these codes work. That's a discussion that's going to be taking place involving rivals.
Whether done through a code or done through authorization, it's discussed with rivals and becomes public. Yeah. So in a sense, the firm can say, I want to have ex ante certainty here. Yeah. It's their choice.
This is your microphone. Or rather your microphone now. So it sounds as if, and I'm a comparative tech lawyer, so I'm not a competition lawyer specifically. It sounds as if we know that the DMA unit in Brussels is desperately understaffed, only looks overstaffed compared to the AI unit, which is barely existing. Same thing with the ACCC, certainly by comparison with Digital Market Unit in London, which is a kind of, I don't know, it's kind of a post-Brexit illusion that Britain's an important player, but it's lovely that people have said such charming things about it over the last 24 hours, which I will convey to them, and they will be delighted. Well, Rod will already have conveyed them to them, and so will Mark Nottingham. We have a couple of Australian expert advisors to the DMU, which you'd hope the ACCC would want to use some of these skills as well, right? This lack of resource amongst the regulators is a huge, huge problem. And Stephen was kind enough to mention that, you know, our old friend Martin Cave kind of was a regulatory god when he was chair of Ofgem. I'm not sure if Martin would necessarily share that that characterization of what happened. He thought telecoms was more complex than energy until he got into energy, and was disabused of that notion, I guess. So we continue to have the problem, and in terms of the anti-circumvention phrase that you quite rightly dislike, and which my brother Philip Marsden would, I'm sure, have opinions about as well. Brother, not brother, I should say. We just always tell people we're brothers. There's this huge inequality of arms which will continue forever. And actually, from what Stephen was saying, I was getting the assumption that even if we do turn the ACCC into some kind of regulatory godhead, which I know is never going to happen, you're still going to be, you know, we're still going to be dragging ourselves along a long, long way behind the leaders in the field. And the most likely healthy outcome for the Australian consumer is what Stephen said, which is the big tech companies either, they don't want the brand reputational damage of pulling out of Australia unless they're Musk, who clearly loves damaging his brand, but then he's the Doge, so I suppose he can do whatever he wants. Is that they just decide, what the hell, we'll just have the same rules. And so Australia gets away with some kind of, you know, very, very thin version of GDPR just because companies can't be bothered to change it, and because they're kind of adopting a shadow California Privacy Act. And in the same way, they adopt some kind of sort of shadowy DMA because companies, you know, these giant, you know, pro-innovation, multi-trillion-dollar companies, we never talked about multi-trillion-dollar companies before 2021, just can't be bothered to abuse the Australian consumer any more than they already are. That's kind of the conclusion, right? Discuss. Over lunch, probably.
You want to respond or?
Yeah, I mean, you know, it is the real possibility, but we already see GDPR influencing Australia. So, I mean, I think, Simon, you were pointing out the lessons from some of this. We've seen GDPR massively favour large firms. There's now a whole slew of economic studies showing that it's the small firms that have suffered the detriment of the costs of GDPR. Do we have GDPR in Australia? Seems like about 50% of the time when I go to those cookies, there's suddenly a reject all, which I happily press. No rule in Australia says they need that. They're just, why would they have a separate web design for Australia? We're a pimple. That's right.
I mean, I would suggest say to that, I agree with the underlying proposition that the resource, yeah, we're obviously going to be resource constrained. An Australian regulator with the global resources of the parties we're talking about, it's always going to be the case. Frankly, the Europeans are, the US, I mean, even the US, you know. Yeah. But actually, I think you get to the point, the point that you go to is an important one. So what does that mean in terms of how do you get the most bang for your buck out of the regulatory resource that you do have, right? And I'm not sure an ever expanding set of very specific and finely tuned codal type constraints where we're chasing rabbits down every conceivable technical hole is the right. I mean, I genuinely think, you know, the Commission, if you look at where I think they have been most effective, it's been where they have taken principled positions that have sent strong deterrent messages to the market about their willingness to enforce particular principles of conduct, cartel conduct, strong ACL around misleading and deceptive conduct. You don't need to set a particular code that sets out thou must say this and thou must not say that, and thou must say this in every single market. For me to go and have compliance sessions with clients and be able to say with a degree of certainty, this is how you need to operate when you're marketing your product, to step on the right side of that. And believe you me, the ACCC takes it seriously and they enforce it, and they've got a team that's well equipped to do that. It is that style of almost outcome type, principle based regulation, I still think has a lot to go for it, especially in circumstances where you're resource constrained. You've got to pick your battles, and you might as well set those. That's another reason why an endlessly expanding scope of very specific technical type code requirements in a particular sector, all of which have to be enforced by a particularly specialized team, is actually, I think, adding to the problem, not to the solution. Because in my experience, regulation expands to fill the desk of the bureaucrat that you've employed to enforce it. It's performative. The whole thing becomes performative. You expose yourself to capture, which of course is then the next step in that process, and you're off to the races, and you've got our energy market. I'm a big fan of capture.
All right. So lunch is waiting. So let's again thank the panelists for the discussion. I also propose to let's applause for Mel, who has put enormous effort in organizing this event, and also our supporting team. So Shahab and Adi for the work.